Hi, my name is Jyotika Malhotra and I'm a legal intern at LEXIS and Company. Today I'll be speaking on Order 6, Rule 17 of CPC. The provisions regarding pleadings are found under Order 6 of the Civil Procedure Code 1908. A pleading is a written form of a statement that is drawn up by both parties to a suit. The statements in writing include the contentions and other details that the opponent needs to know to prepare his or her case for the trial. Statements given by the plaintiff are called a plaint, and the same given by the defendant is called a written statement. Importance of pleading and its relevance to Order 6, Rule 17 of CPC. The concept of amending pleadings can be easily understood if we know the purpose of pleading. Pleading not only defines the issues between the parties but also helps in determining which of the parties has the burden of proof. One can say that it plays an important role throughout the whole process of litigation, as it also helps in determining the range of admissible evidence that the party should adduce at trial. The sole purpose of it is to make each party fully aware of the issues that will be argued so that each party can present appropriate evidence for them. Rule 17 of Order 6 is applicable in a situation where it becomes necessary for a party to make some changes to the pleading. This refers to the process of amending a pleading, which is explained over here. The courts decide a case on the basis of its merits, that is, on the basis of facts, proof, and evidence. Suppose the merits of the case are not completely mentioned in the pleading of a certain case, then the decision made by the court cannot be considered complete justice as the merits were not completely mentioned. It may also happen that the merits that were not mentioned held an important aspect regarding the case. Keeping this in mind, the courts are empowered to grant permission to amend the pleadings. Hence, the concept of amending pleadings steps in. Order 6, Rule 17 of CPC grants permission to the parties to the case to amend their pleadings at any stage of the proceedings. The proviso under this rule says that after the trial has commenced, an application for amendment shall not be allowed. However, it might be allowed if the court thinks that, in spite of due diligence, it was not possible for the party to raise the matter before the trial commenced. This statement can be explained using the following example. A person by the name A files a lawsuit against B. The suit was filed in a hurry because it had some limitations. So after filing the suit, A realizes that there are some important facts, proofs, or documents that he could have added to his pleading earlier, but could not do so as they were not in his knowledge at that time. In this case, the court might give A permission to amend his pleadings. It is a discretionary power of the court to grant permission or not. Now I'll be winding up the video, and if any of you has any questions, please drop them in the comment section. Thank you.